All right, let's call the special meeting of the Montana Board of Investments to order. First item, take notice that this meeting is being recorded on video and audio. Next item, a roll call. Savannah, can you help us with the roll call?
I can. Everything's a little slow today, so bear with me. Thank you so much, Mr. Chair. Good afternoon to you and the members. Jeff Meredith,
Here.
Cindy Youngkin,
Here.
Porter Bennett,
Here.
Tim Kober,
Here.
Maggie Peterson,
Here.
Mark Berry,
Here.
John Milanovich,
Here.
Dan Trost, with his absence, Dwayne Iverson,
Here.
Representative Larry Brewster,
Here.
and Senator Shane Moraju, absent. We do have a quorum. Thank you, Mr. Chair.
All right, thank you. All right, next item, any public comments on issues with board jurisdiction? Hearing none, okay, we'll move on to the development agreements. So Dan, take it away. You guys are on mute.
That's so 2020 of me. I apologize. Okay, Mr. Chairman, members, first, thank you for responding on the short notice. I'm going to tackle this in 4 parts, 3 of which will be before you make a decision. 1, how we got here. 2, why we're here. 3, what is before you. And then after we get through that, where do we go from here? So those 4 elements. First, how we got here. The board has been in the direct real estate business for 25 years. Our first endeavor in this place was the building that we meet in. This was undertaken and built with trust fund assets in 1999. And the portfolio has grown from there. Sometimes at the request of the legislature, sometimes at the request of the board, sometimes at the request of the land board. It has varied. We've been very, very successful with it. Our returns range from 29% per year down to about 7.27, which is right around our actuarial hurdle for cap. But as you're aware, these are trust fund assets, so we're comparing ourselves to, are we returning capital in excess of the bond pool, which is in that 5% range. So our participants have done well by these investments. And unfortunately, that has been discovered. So whether that's the governor's office or the legislature, they have been giving us more. In the 2023 legislature, they passed a law, and Governor Gianforte signed, that we will do the Deer Lodge development. This last session, they passed a law, and the governor signed, that we will do the behavioral health facility in eastern Montana. From time to time, we get the one-offs, and this would be in that one-off category, as was USF&G earlier this year. A $5 million proposal to acquire or build a new Bureau of Weights and Measures facility for the Department of Labor, which brings me to why we're here now. The Department of Labor received notice that they will no longer have that their lease that expires on October 1st for the facility they have on Airport Road in Helena, that houses all of the specialized equipment that travels around the state and confirms that the gas stations are selling you a gallon of gas, and the weights at the grocery store are charging you for 2 pounds of cherries and not a pound, 1.8 pounds, and charging you for 2, that they will be no longer have a place to go. The governor's budget office and the Department of Labor approached me to help them facilitate a fix for this, in that we would go build or acquire space for the Department of Labor to house both the Bureau of Weights and Measures, but also the building codes section. They're currently occupying a floor over at the South Park Tower, the old federal building. The Commissioner of Labor would like to shrink her footprint and lower her rent expenses by combining those two units into one facility owned by BOI. They'll shrink their footprint by $2,000 a square foot and cut their rents by approximately half. So they save money in the process of doing this. We get $5 million into the trust fund investment pool from the budget office, and then the ongoing rent payments from the Department of Labor for the space. So it not only helps one of our sister agencies, but we get the income that is then distributed to all of the participants of trust fund. What is before you is the development agreement that the budget director, the Commissioner of Labor, and I negotiated over the last several weeks. What I'll say the new development is, since we sent this out, the Governor's General Counsel has provided comments and edits that are before you in the email I sent last night under forward:edits. That was the email that came through. You also got a document from me, a PDF that was WM Agreement 6_25 edits. That's a PDF. There are some places where the changes were great, no problem, no concerns. There are some places where Court and I share a concern that the edits are not in the board's best interest. And I'm going to have Court walk you through those substantive issues, as well as why we believe our proposal is superior to the edits that were submitted yesterday. So, Court.
So which one are you going to be talking about, Court? The amended one?
What I'm going to do is look at the agreement as a whole,
Okay,
and particularly the version that Dan sent that has the
Okay.
version he's recommending to the board,
so the amended one.
the amended one, and contrasting it with some of the suggestions by Governor's Council as to why I like the language in the amended version that Dan suggests better for the board than the Governor's Council wants. And now many of the changes we just incorporated in. Labor and Industry wanted, for example, their full name. The end industry with the ampersand absolutely did that. We made for consistency agreement throughout the entire document. Some minor changes to how the unneeded insurance was. Yep, totally agreed with Governor's Council and accepted those. If we look to the second paragraph, where it basically says the change that they would suggest was once the building was completed, it's an investment asset. Anything that's really in the board, once it's over here, be it cash or a building or jewelry or anything, it's an investment. We only have one standard, fiduciary standard of an investment. I don't know what the change would legally do. But we have no choice, and my recommendation to you is to treat any asset, cash or building, as an investment, and the document should reflect that as well.
Okay, Court, I have a question on that. So the last sentence on that paragraph says the facility will be as an investment security of the trust fund's investment pool.
Yep.
So that was in the original, right?
Yes.
Okay, all right, so it's there already.
Yeah.
Okay,
The question here was whether or not it had to be completed to be an investment, and cash assets are also an investment. When we hold them, we still hold a fiduciary obligation.
Yep.
We just don't want any confusion, like whether it's in cash form or the building form or an incomplete building, it's still an asset. It's
yes,
still investment security.
yes.
So, Court, I have a question.
Absolutely.
The facility implies there's something physical there, but it's an investment. Once we get $5 million, it's an investment. So is the word facility appropriate there?
The facility, the moment we have it, like that's what that group of the investment is. It's cash for the facility, it's facility being built and facility being completed.
Is that defined someplace?
Yeah, maybe we should define that, huh?
It is not. Part of this is it's also just an agreement between the three parties to make sure it's binding. This will not be the final or only document here. We certainly could define it. But the trouble we have in all of this is we're up against a little bit of a time crunch, not of our making, But like July 1st comes around, the money may not be there to move there. So we certainly could define it, or we could,
The purpose of putting the facility will be an investment security of the trust fund's investment pool was more that we're determining that it's a TFIP investment upfront. Not that the facility, the purpose of that sentence is saying this will be held in TFIP, not saying that it's just sort of floating around in the hinter unowned. The cash in the asset will be TFIP beginning to end.
yeah. And the first part of the sentence indicates it's money for the facility, which is in some ways the definition.
Sure.
And it's to make sure that like that money is for that facility. And it more deals with if there's rescission later on at one of the later points of how much would be returned. The next one is going to be the trickier one, and it's one where we've had multiple, like not only this initial suggestion, but a couple other versions that have come to us as comments. What we have in ours, and the entire purpose of this, and before we get into the weeds a little bit, is this is an agreement between the three different parts of government to bind the money, make clear the purpose, and an understanding of what's going to happen. There is a sample lease included, but there'll be a final lease somewhere down the road. At some point, we will likely, as the Board of Investment, hire a third party, go through a process to get a third party to acquire, build, do this actual work. There'll be more contracts, more details later. This was to create that it was out of the control of the budget office into our fiduciary care for this purpose, and that labor, the eventual benefited party, was of the understanding they'd be entering into a 20-year lease when it's done. The agreement is just supposed to codify that between the various parties. And I know Cindy and I know Anita and even I struggle with this because unlike traditional contracts, you don't have that offer obligation, the binding consideration you see in a lot of actual contractual documents. So I have to create enough of an obligation to actually bind the money. And so everybody has to have at least something that they're giving in consideration to make this binding. The budget office is $5 million. Us, it's our agreement to, in good faith, work to get and build and construct or acquire this building. And labor, it's that they will eventually lease it and pay us money, and that money will go into our trust fund, thus benefiting the beneficiaries that we owe a fiduciary obligation to. Now, what we're trying to get to in this third paragraph is, hey, other parties to this, we're going to use a third party. Like Dan is not going to physically go build this thing. And God forbid, I, as the lawyer, am the one approving it. So there's going to be third parties. And yes, those third parties have to follow laws. We're understanding that. Now, there was some talk. I know I saw an email from John and Anita and I have been going back and forth a little bit on this, is how much do we have to state affirmatively that the Board of Investment has to follow state, federal, local laws? Well, here's a dirty secret. All government entities at all times must try to follow state and federal laws. It's a big deal, usually involving a lawsuit by the Attorney General if you don't. So we usually don't. Hi, John.
So, sorry, go ahead.
So part of what we're trying to do is say not so much will BOI follow the law, or for that matter, we don't require the budget office to say they're not going to rob a bank to get the $5 million. What we're trying to make sure is we're telling the other two departments that we will be responsible in the end for hiring a third party, and ideally we'll do it in compliance with state law as it relates to, and the key sentence there is actually the last one, which neither the governor's office nor I nor labor wanted to argue over. It's always remained the same in all versions. Such use we treat as an investment activity and not a governmental direct building. And if what the budget office wanted us to do was build a direct building, then you should be in Department of Admin, you should be going through procurement. That's the government direct building. What they're saying is they want us to make an investment in a building which has to show returns, which has to follow investment rules and investment acquisition rules and laws, which is we usually use third parties. And that's what we're planning to do. And so for us, like the key sentence was the back end, and neither Anita, the governor's council, myself, O'Connor over for labor suggested that wasn't what the intent of this agreement was. The first part, like that we're going to do third parties and exactly how we're going to ensure laws, like the wording can get overly broad if we're not careful and imply that we don't normally follow the law, which is certainly not what we want to intend or imply.
I guess
Court, hold on a second, John. Just on this, I mean, I'm not sure what the Governor General Council's position on this, but it almost seems like because you're kind of saying the same thing in the first sentence on your version. And you can almost just rephrase it to BOI may use independent contractors to build, acquire, and manage the building as appropriate and in accordance with state and federal law governing the building acquisition and leasing. And kind of probably, I see where their revisions strike what your intent was with the sentence. But if they, obviously we're going to follow state and federal law, in this agreement. So you could maybe kind of just merge the two together. And if nobody has an issue with that, maybe it's easier because I'm not a lawyer to do that. But seems like one we could kind of just create a sentence that covers both, and maybe just instead of allowed by law, it uses their language in some form, and we could.
We've been trying to actually merge that this afternoon, going back and forth with different language. You get a couple lawyers in a room, it's really hard to agree on the exact wording. I'm really conscious about not overstepping into Department of Admin's territory, where we say we'll vouch for the lease compliance, because that's actually what DOA does, or we'll vouch for all construction compliance, because one of the parties to this contract is Department of Labor, and they'd be like, hey, have you ever looked at what we actually regulate? So I think there is a way to get there, and that's what we're trying for wording.
Read them the language we sent over earlier.
This is the last version we sent over to Anita Milanovich shortly before this meeting. Sorry, I've got too many.
Just read it from the paper.
Because that's not what I sent out.
Okay.
BOI will be the party responsible.
No.
BOI, subject to all acceptable state and federal laws, may use independent contractors to build, acquire, and manage the building.
Yeah, there you go. That's what I was thinking. That's.
Okay. Do we have general consensus that we should amend that paragraph to read that from the board?
Could you read it again, Court?
Absolutely. BOI, subject to all acceptable state and federal laws, may use independent contractors to build, acquire, and manage the building.
And that's going into the third paragraph of the agreement?
Yep.
Okay.
It would replace that first sentence, but not the second sentence would remain the same since no one has proposed changes to it.
Okay.
Works for me.
Yeah, I think that's an easy adjustment, in my opinion, as well.
Yeah, I agree. There's no, so I do think that obviously that's where our liability is. And so whether it's Anita or whoever, that's my, I read that and that's my concern. So we haven't gone down the road. This process has not been started. We have not reached out to, where are we at with this process? i.e. have consultants been hired? Are we already in the middle of this, or is this brand new, right? Zero. So no one's been reached out to.
We have a contractor and an architect on at all times through DMA, our property manager. So when we went out and did a solicitation, what was it, 3 years ago? 3 years ago, they were the successful, they got the contract. So we have one on retainer, and that's part of the reason why both the legislature and the budget office wanted to use us is we're already ahead of the process. We went.
I can understand that. but Dan, I mean, like this is where like we're gonna differ because what's gonna happen, what that leads us to is let's say I'm a builder in wherever this is, Helena, and they're gonna, I mean, if there's an opportunity in court, maybe I'm wrong here, and I haven't talked to Anita about this. This is my personal view. Like where we have a problem is if we're not following, you know, if I'm a builder and I hear, oh, the state's building it's BOI's building a new building and I wasn't involved in an opportunity to bid on it, we're going to have a problem. Am I wrong there? Or is that, I mean, like it's certainly as a management company, if we are a real estate manager, we can say, hey, listen, we use Frank's, you know, whatever, this is what we're doing. But I think that process, yeah, this would be where my concern would be. My concern would be that if that is how we're going to be, how we move forward on buildings, that your people rightfully in the city who are in these industries are going to be like, well, where was the bid? And that's from my understanding what the administration has purchasing groups to do this or whatever. I mean, that's what they do every day. My concern is that and if you've taught, I mean, I know my concern is that we don't get, like someone doesn't come back in a year and say, hey, what happened to the bid here process? Or what was the process used to hire X, Y, and Z, and why wasn't it done that way? And
But
unless we are established independently, I think that's my concern. So can someone
John,
speak
so
to that?
I assume on the second sentence, and correct me if I'm wrong, Court, Dan, Cindy, others, I think the key term there is that this is investment activity, not governmental direct building. So similar to, any other investments that we're doing, within the trust fund investment pool that may relate to real estate or REITs, those aren't subject to, governmental bid requirements.
Right.
I agree with you that it could
You
raise
see
some
the issue.
complaints. It could raise some complaints, but correct me if I'm wrong, I don't think the process that they intend to use would, have any
What would
legal
be
merit.
cleaner, I think I mean, I guess what I would recommend, and I am concerned about that. And that's not like it's obviously like a hypothetical concern, but as a board member, if I see liability, it's something like that where, hey, we aren't look, if we follow the statute of the state where we're part of the state, and there's, we are I mean, I think that is where it would be nice to have the belts and suspenders of, hey, there's been an official process here. And maybe that's something we do in the future. I mean, I know we're down the road with this one, but like that is of concern to me.
So
It's a concern to me too, John.
So let me address both of your concerns. This last session, based on the Procurement Act not being followed or being circumvented, the lottery was amended back into the State Procurement Act. The Board of Investments is now the only named state agency in the State Procurement Act, and we are specifically exempted from doing procurement on securities. This building is a security. So most recent legislative sessions specifically addressed this, and that is, so I think we have to follow the next logical step. Let's say there's a fund in Montana who wants some provision of the pension fund. Why didn't we get it? I think by saying that we are going to go down the governmental path as opposed to the investment path, we create substantial liability for our participants that they will get that we will be doing some sort of local favoritism as opposed to underwriting a process and a fund according to our fiduciary obligations.
How is the building a security? Define security, because I know
It has-
I know how to turn a building into a security, or I've seen that happen. So have we, I mean, how do you envision the building being a security?
It will be
But by
assigned to
the term of
CUSIP.
papered
It will
and
be assigned
tradable.
to CUSIP as every other building we have is assigned to CUSIP and treated as an asset of the investment pools.
Interesting.
See, you've done this a number of times before, haven't you?
Yes.
So that's to me the basic point is that that's where the precedent is. Why would you change it for this?
Well, in my opinion, if you keep pushing the envelope without having a public process for selecting a builder and that sort of thing, we're gonna find ourselves in trouble and having this provision taken out from under us, or having buildings exempted from being a security. So you can't. I don't know if you can push the envelope as much as is being presented to us at this time. I can see somebody.
Multiple concerns there are both John's concern. There are legitimate concerns here.
Mhm.
The first thing from like the legal perspective, are you within the letter of the law? Yes. The most recent legislative session, as you pointed out, they specifically addressed it. Real property is listed under the auditor as one of the possible things that are a security. So, you know, as a lawyer, can I defend this in good faith? Yeah. And I think it's one of those ones where it's pretty clearly in the white. Now, there is other types of liability, both public perception, legislative perception, and just general rules of equity and fairness. And I think that's more what you're often getting to. I used to come from the Department of Agriculture, and there's an old saying there: pigs get fed, hogs get slaughtered. And there's a thin line between a pig and a hog, and you don't want to cross that line. And I think the board could fairly say that if you're not feeling comfortable, that you're feeling this is hoggish behavior, that we are taking advantage of the law and the letter of the law and getting past the point of the law. Now, what we've done is we've been asked to do this favor by the governor's budget office. And when I drafted this, I said, hey, I need you to agree that this is a security. That's why that second sentence is there. Because if it wasn't there, if they come back to us and said, no, this is just a governmental building, I'd say there's a Department of Admin and the normal procurement and bid process for doing that. If a developer were to come to Dan and say, I'm suing you for failing to follow procurement, the correct way of coming in front of the Board of Investment is we could sometimes solicit for bids to become that procurer, but they're not closed nor necessarily exclusive. If you want to provide services and investment stuff to the board, we vet them in a professional manner. So it doesn't say we can only have one developer. It doesn't say we can only have one person who provides the service to us. And I don't believe we do. I think we have many, and some in other states as well, that when we look at real property assets. So this isn't necessarily exclusive. And then if we had multiple providers that could provide it that were already vetted as investor grade, we would have to look to that process and how to do it. Or we could choose to go down that road, but that might defeat the purpose. Like if we go back to if the board says, hey, we'd like to see this viewed as a governmental purchase, not an investment. I would say, hey, the law doesn't necessarily reflect that, but that's what the board has power. It has agency. But then what you're really telling the governor's office is please use your Department of Admin. Please don't use your Board of Investment.
Maybe, I mean, I talked to Dan about this a little earlier today. I mean, like, that's why I think going forward, I mean, I wanted to raise this concern because I think that's a legitimate concern. And, maybe, I mean, what's nice is when the legislature says, here's what the story is and here's what's happening. And maybe we get out of the business of building. I mean, maybe, this might, I mean, I guess whatever the board's decision is here, read this item. But I would want us to be considering that this is something that we shouldn't be, it will come back to bite us if we did this a whole bunch of times. I mean, I'm from Butte. I know, like, someone doesn't get if it's not a public bid, like what the response of the people is or whatever. At some point, there's going to be there's these buildings being built by what they perceive to be the government in Montana, and why wasn't I able to get in on that? That's what I'm concerned about. And it can be that maybe because of the short notice here, we just kind of say, hey, let's move on with the language we have and get this one done. But I think we got to move going forward. I think it would make sense to throw it back to the legislature and to say no to the governor's office or whatever and say, this is not a business we want to. We either want the legislature or the board or the governor's office procuring it on their own, because what is the minuscule 20% return on a $800,000 investment is nothing but liability to the fund overall, and as far as the attribution of what the return of the fund is, right? I mean, we're talking fractions of pennies, but from a liability standpoint, a lot larger. I mean, Court, what do you think? What's your opinion there from a strategy standpoint? And Dan, what's your opinion from a strategy standpoint going forward?
My strategy is we are one of the tools available to the governor and the legislature. We have a 25-year process articulated that has been successful. The legislature and the governor can choose which path they go down. They can come to us under our well-articulated process, or they can go down the D of A procurement well-articulated process. That's the way it has been. That's the way it is. In this instance, the governor chose to go with us because we get to return that money to the trust fund investment pool. So in this instance, when Town Pump and Safeway and everyone pays the fees to get their scales evaluated and certified on an annual basis, that money goes to the Weights and Measures Division. That money goes to when someone gets their building inspected, the Building Codes Division of Labor pays. That's called state special revenue. They will then pay us into the trust fund investment pool as state special revenue and receive the funds on the back end as general fund revenue, which is what the governor's objective is, and the legislature's, frankly, maximize general fund revenue so they have it for other purposes. That's the path that they actively chose when both paths were available to them in this instance. I think it is wise to have that flexibility for the state that, this is a $5 million building on a $750 million 27 biennium building program. There will be plenty to bid on. I think the legislature and the governor knew the choice they were making when they made it. And we should, if we want to limit when we receive those requests, that's one thing. I would urge the board not to close down the door, and that gets back to the question John and I discussed earlier. We had the governor's office and the Department of Labor request their assistance in a short time frame to make this work, because you have an October 1 vacate date. If you were to go through the other process, you will be many, many years out before you're able to get there. So I don't necessarily disagree with John's liability, not necessarily financial liability perspective. I do disagree with how he gets there, because I think it sets a sort of dangerous precedent for all of the other assets that, we don't underwrite these things from a fiduciary standpoint, but we worry about the potential political liabilities, which is a thing. But that's part of the challenge of being the fiduciary, that if someone protests us owning hotels in Southern California that aren't labor friendly, we have to take that one on the chin because it's producing a good return for the fund. If someone doesn't necessarily like how we go about building buildings, but it's producing a good return for the fund in whatever value, those are the things we have to take on the chin. The issue here is it's more home. You can call your legislator, you can call the governor, you can complain. And it's something we deal with in our regular funds on a daily basis. There's an instance a couple of years ago, we were underwriting a housing fund in Montana. If we would have invested, it would have been part of what washed down the Gallatin River when the wastewater treatment facility went. That wouldn't have been a great fund to be in from a liability perspective. So I think John and I are getting to the same place that a longer term conversation is warranted. I think we get there in different paths. But for the purposes, and that's why I put where do we go from here as the last item. I think we do need to have that conversation. I think we need to acknowledge what liabilities we're willing to take on and which non-financial liabilities we're willing to take on and which we're not, and make our determination in August after we vet it and get through, frankly, this agreement, because this is up against a fiscal year legal timeline that I think in some instances did force the hand of the administration as well. So sorry that waxed eloquent.
I think that's a good point. I mean, I think overall there's obviously some concerns from both John and Mark, and I see the concerns. I think they're valid. I think the point is, I think we got to work through this contract today, make a decision on this. Let's revisit kind of our overall opinion on how we want to proceed with these direct investments in the future. Hopefully at August, and we can have a more in-depth discussion at that point and potentially gain some more comfort from everybody.
Do we want to move the question, or is there more? Court, do you need to discuss any? Were the other changes, they seemed perfunctory, but was there another change that should be discussed?
There's a few other little ones I just walked you through relatively quickly.
Sure.
Most of them were accepted. The next one is section 1. We didn't accept that change because we got the investment language is up above. So since we aren't striking it there's no reason for it to appear here. It just end up redundant. In section 7, the governor's office said, hey, you don't even need to have this. You're going to follow state law. We like to indicate that we're going to be the party that's going to go do that because we have to sign the other leases and contracts. And so, while I respect their willingness to get us out of having to do work, like as the lawyer, I'm your guys' lawyer, I'm like, yeah, we're going to make sure that we protect all the other assets when engaging in this behavior. And yeah, it will in most cases follow and mirror what other state agencies do. We use state contracts for them. Section 8, this was to make it more binding. They wanted any party can cancel at any time. Well, it's hard for me to argue that we bound the money if any party can cancel at any time. The way this contract is really working, and what makes it, and I think, and I'll touch on it at the end. The budget office gives us $5 million, basically as a strings attached donation or grant. We'll give you $5 million if you build this building for this use. Okay, we either accept it or we don't. Once we accept it, we don't want them to be able to pull it back because then they haven't bound the money, and therefore any like the legislative auditor or anybody else will say that money wasn't committed. If they could just pull it back the day after or any other day. Labor, we need them to commit that they're going to lease it when we're done if it meets their specs, because otherwise we'll have wasted $5 million of state money. And if they can cancel after the building is built, but for no particularly any reason they want, we'll be left with an asset in which the odds that anybody else needs a special floor and everything else for would be useless. We have the right to cancel, not because we want to cancel, but there's a possibility that the board, because of liability issues or issues that arise, like right now I have a drawing of what they want, which I assume isn't life size because it's only this big. And we haven't even started the process. It's possible if they gave us $5 million, this is an $8 million project, and at some point we go, here's your money back. We tried in good faith. It can't be built for that time or in that time frame. And basically what we want to say is we're willing to do this. We're willing to undertake some of the risk, as John was indicating. But we're the one that can back out, because the reality is if the person giving us the $5 million backs out, then they've already given it to us. It's already under our control. So they can back out until they give it to us. I guess that's true. And then labor can't back out unless, without giving proper notice and all of us agreeing. We all agree that if all of us agree that the project is a no-go, then it's done. But having every single party have the ability to back out could create some really weird situations. And in this case, given them giving us the money is contingent on labor eventually leasing from us. Otherwise, none of this makes logical sense. So I understand the reason for it, but it doesn't. Our language is better. Number 12, they suggested adding presently to the names. We think there's a better solution. And I ran this by Anita and she agreed. Strike the names, just leave the titles. So executive director, board of investment, director. That way, you know, I don't want to create the precedent of saying presently every time because that'd always be true for every contract ever. So, but the titles actually make a lot more sense.
Well, Court, when you say that, you ought to do it in the lease agreement too. And I understand that the lease agreement is a draft right now, but it ought to be the same way in that too.
Absolutely. The only reason that the names are used in the lease agreement is the DocuSign requires it to be linked. The actual physical signature we use when doing leases has to link to an individual.
Yeah, but that's in the signature line. So
yeah, but throughout the whole document, the other stuff, absolutely agree. And for the notices in particular.
Mm-hmm.
And then in section 13. Gotta get my 13 to match up with here.
This is the third party.
Yeah, it's again just third party assignment.
Yeah, the BOA may assign the actual, they struck actual acquisition, building or management and limited to just the management could be contracted with a third party. We feel like we need all three of those in order to proceed.
Okay, now why is that, Dan? So because if we determine that it's not the right investment for the board, then we want to sell the building. Is that why you want to leave this in here?
No, we would be able to assign going out. So for instance, we're not going to prepare any purchasing docs if we're going to go buy the building. If we find something that meets their needs, we'll get a realtor or somebody to help us do those docs. We're going to assign the construction of the building to DMA under our existing contract. The management obviously will be assigned. So those three items move as a package throughout the document that we can assign any of those tasks to that third party.
Okay, but the owner of the building is going to be the Board of Investments.
The owner of the building is going to be the trust fund investment pool of the Board of Investments.
Okay.
Yes.
Yeah, and I'm not sure what the exact logic on that one was from the governor's office, but I don't think the intent was to bind our hands on it to just the management. I think it was just time crunch and a lot of different issues in the air. As to the general liability question, I think John and Mark bring up good points. And what I always balance that with is just about everything the board does could cause liability. Every time our employees drive a car, every time they sign a contract, there's potential liability there. Like there's always someone that's going to have their ox gored or whatnot. The other thing we always have to balance that with is we have a duty as fiduciaries to get good returns for our investment. And if we peeled away the whole governor's office from this, if a random person was going to give us $5 million to build this building and say, you get to keep all of the rent and I'll give you the $5 million to build it,
Sure.
It would be hard for us, the fiduciary, to just say, well, we might get sued. Some people might get upset. We're going to turn a $5 million gift down. If we do that, then I have to worry that somebody who has trust will say, why you weren't actually acting as my good fiduciary. You turned money down.
Right. It's more of, well, that you take the money and then make an open bid, right? But I understand, and there's reasons why they have procurement agency, etc. I mean, I get it. I think we should move the question, and I'm sure I'm not the only one, which would be adoption of the development agreement with the using court's language, except for on paragraph 3, the kind of discussion that we came to a nice way to word that both sides will likely agree to. Does that make sense? I mean, that's not a really good motion, so forgive me for not having it defined. I forgot the exact wording of paragraph 3 that we decided. But
John,
Yeah.
if I could repeat your motion to make sure I understand it. Move adoption of the development agreement as presented by court in document WM agreement 6_25 with the change to the first sentence of paragraph 3 to read BOI subject to all applicable law may use independent contractors to build, acquire, and manage the building. Is that your motion?
yes, I don't know the exact, I don't know what has been adopted as well, so I'm going to trust that that is what a court can merge whatever changes were agreed to already into whatever document you just said.
So that would be the one with the blue lines. It would include that document, the first paragraph of the first sentence of paragraph 3 would read BOI subject to all applicable law may use independent contractors to build, acquire, and manage the building, and we would eliminate the names in this is a question that we would eliminate the names in the latter section and only refer to the section title in section 12.
Yes.
I would second that.
All right, we've got a motion and a second.
I have another question.
Go ahead, Cindy.
Is the
Thank you.
paragraph 3 then, is that last sentence, such use will be treated as an investment activity and not governmental direct building? Is that to stay in there?
That is to stay in there, yes.
Nobody proposed changing it.
Okay, and then what's the final read on section 8 as determination? It reverts back to the way it was.
So it would read in the version that I sent around reads BOI may terminate by giving notice to the other parties if it is unable to complete the project for any reason. All uninvested funds will be returned to the OBPP.
Okay, thanks. Just wanted to be clear on that.
Yep.
Thanks. Any other questions?
So, but if you find, I don't know where the $5 million came from. Did you give that estimate to them, Dan?
The $5 million, in all honest and fairness, is they have to get this money committed by the end of the legal fiscal year, and the time the money runs out, under I believe it's House Bill 4. So we don't know what this thing's going to cost. It could be anywhere from $2 to $5 million, but $5 million was the north side, and anything in excess of that goes back.
Okay, but what if it ends up to be in excess of $5 million and you get a new fiscal year? Can you amend this agreement and get some additional funds, or what? How can that work?
If we can't build this thing for $5 million, that is when court scenario would come in and say, we don't think we can do it for this amount of money. You got to find another option. So.
Okay.
All right, any other questions? All right, we got a motion and a second. All in favor?
Aye.
Opposed?
I'm going to agree with the proposal. So, but I do have major concerns.
All right, so not opposed.
Not opposed.
Any opposed? All right, motion passes.
All right. I know the hour is late and people have tea times, or they're going to be driving their cart out to the fifth hole to catch up. Where do we go from here? The juice is not worth the squeeze in some instances. And given how painful a $5 million endeavor has been, I would request that we, in line with John and Mark's comments, visit when and where and how we take projects like this or proceed with projects like this. I think it is exceedingly clear when the legislature votes, knowing full well what our process is, and the governor signs the legislation, that that's a direction and we should proceed, and the law is the law and we go. Everybody's eyes wide open. That would be my recommendation and my thought, and if it is amenable to the board, I would circulate a policy revision that for you all to consider at the August board meeting after some consultations with the budget office and others.
That's fine.
And Dan, in addition to that, I think we need to look at it to make sure or to determine whether some legislation or something in statute to make it clear that when the Board of Investments owns or acquires or builds real property, that our process is different than the regular procurement process if, you know, any other governmental entity wants to build a building, and whether the public bidding is necessary and all that kind of stuff. A little clarity in statute might be in order.
What I guess I would say be careful what you ask for in that instance. Because if we go in with a statute that says A, it could very easily be hijacked to say B, and now the fiduciary obligations of the board, where you have the duty to go perform a certain task, is now defined separately in statute. I think your governance policy and your procedure manuals are in excess of any administrative rule or other guiding document that is out there. I would be very concerned about putting up some sort of statutory change where you're a quasi-judicial board. You get to make certain determinations as an entity, just like you get to hire staff and procure things of that nature.
But then in the policy that we might want to have, if those statutes, if those statutes could be specifically stated in there,
yes,
so it's very
that
clear.
we can
And I'm not
absolutely
suggesting
do.
Yes, and I'm not necessarily suggesting I want it in statute. I'm just saying maybe we need to think about whether there should be something in statute. Give it a critical eye.
Yes, so we will incorporate, so on the bottom of all of our policies, it references the statutes that are applicable to that particular policy. In this instance, we'll be a little more direct, pursuant to MCA blah, 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 then fill in the policy. So yes, we will draft it in that way. So sorry, Mr. Chairman.
That's good. I think another thing to discuss, we kind of brought up obviously non-financial liability. I think, something else that we should consider and potentially have reviewed between now and August, or at least have it prepped for August, is maybe some more clarity on conflicts of interest. Obviously, it comes up with me quite a bit with my role at the bank and our interrelationship with the board. And obviously in this circumstance, just with John, just to get some clarity from for the board and for all of the board members on, when and how we should proceed and when we might want to step back. Not saying this is the case. I'm just looking for some clarity for myself as well as the other board members. So Dan, if you have a suggestion on how to proceed with that, we could go down that path.
Okay, let me ponder. I think there's a couple of avenues that I've seen used. I will be totally honest, I'm a little nervous to put court in the middle of making determinations on where board members can and cannot function, because he's your employee and that puts him in a hell of a rough spot. So I think some form of outside counsel looking at that. Frankly, the place that sort of comes to mind is the Attorney General, as we did with the equity thing. Hey, there's some nuance here. You give us the opinion. That way it's binding as law unless the law has changed and we don't have to deal with it. But that's something the board has to direct staff to do. So I will be in consultation with all of you between now and August to bring you something on how we do that.
I'm sorry, could you define this, Jeff? Because are you saying that because my wife is the attorney for the governor, that that's a conflict of interest then? I mean, help me understand.
I was
I
not
mean, it's
saying
fine if
that.
that's a position. I just want to know what we're talking about.
Yeah, so I wasn't saying that. I was saying that, obviously, speaking of kind of non-financial liability, the perception could be there as to whether or not, you know, there's independence. So we're just looking for clarity. Similar to my position at the bank, oftentimes things come through that the bank's involved in, and we could get clarity and perception, clarity on that for all of the board members. So.
And John, let me even though I am you guys' employee, there's an advantage of being civil service sometimes. There probably is a conflict at some level, but the question is an acceptable conflict. My dad was the sheriff, which also meant he was the bailiff in the county courthouse in Macomb County, and many defense attorneys thought that was not okay for him to be both the sheriff, witness, and bailiff of during a jury trial. But the judges would say, "But we're a small town. Who else is going to do it?" And we're a small state. No one's saying there's impropriety in.
Well, I mean, I hear that, but you have no idea how frustrating that is when I've got to go into my bedroom at night with my wife and not talk about these things when I have actual questions, and we don't because of these issues. So, I appreciate the thinking, but. I'm more concerned about if there's conflicts of interest. I mean, I'm happy to do whatever. I mean, if there's a perceived conflict of interest, I was voted and approved by the legislature, and so I believe I have full independence on this board. And that Court, you work for me, Dan, you work for us. We are the board, and I am a board member, and I take it pretty darn seriously. So. Happy to do whatever, you guys do whatever you think is appropriate from a standard policy. But all I know is that I went in front of the legislature and was approved by the legislature and was nominated by the governor. So, and we do take this pretty seriously in my family, obviously. So anyway, there you go.
Just so you know, I serve on both boards, and there are times I have to recuse myself.
Sure.
Because of the topic or the person, somebody from Butte that I might know. I can't, I can be objective, but it doesn't
That's
mean
very
you want
fair.
me to be objective.
Absolutely.
So there are times you may have to step back and say, I'm a little close to this. Maybe I have to recuse myself, but we all have that responsibility. So.
Yep.
Yeah, it's no indication of all other matters related to it. It's just from a perception standpoint, it's negotiating a binding contract, and you have the spouse on the other side of the contract. And it would be nice. I would assume it'd be nice for you to get some clarity as well, just from a potential liability standpoint on that moving forward.
Okay, I will have something for August. I will let you know when this thing gets signed and when we're off to the races.
All right, thanks.
Thank you.
Any other comments? If not,
Alrighty.
meeting adjourned.
Happy 4th. See ya.
Happy 4th.
See ya.